33 years, and before that I was in the Jefferson County DA's office. So it looks like I may make this a career.
Let's see if you're,
Am I?
I was going to say, let me turn you on,
Okay.
but maybe that ain't what I need to say.
No. Yes, yes.
Now try.
Okay, can you hear me now?
Yes, sir.
Okay, good, good, all right. As I was saying, I've been in the U.S. Attorney's Office 33 years. I was a state prosecutor before that, so I may make this a career now if I stick with it. This is a challenging thing to talk about, the effects of media releases on criminal trials, because media releases have a profound effect on criminal trials. Let's talk about that a little bit. You know, why do we do media releases? Well, one is we want the public to know what we're doing, okay? Why we're in these high-paid, specialized positions that, you know, we're worth that. This is what we're doing for you. Another thing is we want to deter other folks from committing crime. So we let them know, look, this person's been charged with this crime. So, you know, you shouldn't do it. Another thing is we may need to ask for the public's help in a situation. And that's a valid reason to have a news release or a press conference. Now, there are some folks who would say that news releases or press conferences are done to further the ambitions of some of the people who are speaking. That may be so, but I'm not going to get into that. But those are some of the reasons why to have a news conference or a news release. So who are we talking to when we have a news conference? Okay? We're talking to the general public, but more specifically, we're talking to the victims of the crimes. We're talking to those who may be involved in the crime but aren't yet charged. We're talking to other people who may be about to commit a crime, but we're also talking to judges and we're talking to jurors. Many times jurors will hear that somebody has been charged with a crime. They may have been indicted by the grand jury. And that may be enough in some jurors' minds to think this person is guilty because they've been indicted. Whether they think that consciously or subconsciously, they may already begin leaning that way. And we don't know who that juror is who's going to be in the jury box. So we're talking to the whole pool out there. So we have to be very careful. Now, the facts that are released about a crime may cause jurors to make up their mind about a case, about a defendant, even though they haven't heard all the facts or they haven't heard any potential defenses that are out there. They may go ahead and say, well, this guy's been indicted for possession of child pornography, therefore he's guilty, okay? And they're not, so we have to be very careful to make sure that the defendant gets a fair trial. That's my job too. I'm a prosecutor. I've been a prosecutor for almost 40 years, but my job is still to see that the defendant gets a fair trial. Another thing is that if a juror hears facts in a news conference, and then they go to trial, they're going to expect to hear about those facts at trial. Even if those facts may not be necessary to prove the crime, they're still going to hold the state or the government responsible for proving those things they heard about. So we don't want to make it harder on ourselves to convict somebody because we add a lot more to the case than needs to be there. Now, we oftentimes see defense attorneys who, after an indictment, will go up there and start talking about how innocent their defendant is. They're talking to that same pool of jurors out there that we're talking to. And they're going to try to put in, sometimes they will try to interject things that are inadmissible in a case. Something that they couldn't get into court if they tried because it may deal with race. You know, that may claim that this prosecution is based on the race of the defendant. Or they may say, well, no, this case came about because of some misconduct by the police. and try to put that thought in the back of jurors' minds to begin with before it ever gets to trial, so that it's something that they can, again, begin to harp on in the course of the trial. Now, prior to trial, we are limited in what we can say about a case. There are generally two types of news conferences or news releases. One is if somebody is charged with a crime, and that's usually made by the investigative agencies that are involved. And then there's another news release or press release that's done after someone has been charged through filing a complaint, filing an information, or the return of indictment. And that is usually done by the prosecuting authority, although many times we'll have both the investigative agency and the prosecutor folks there at the same news conference. We'd like to do that and try to do that in almost every instance. But we are limited by what we can say to the four corners of that charging document. The facts that are set out in that charging document, we are free to talk about, okay? But if facts are not in that document, then we should not talk about it. That's the Department of Justice policy. And it's probably a good one because we don't want to go off on other things. And I'll give you, we had a case, and I can't go into the name of it, but I can tell you that at a news conference in the past, we've had a person get up and talk about a case, and he said a little bit more than he should have during the course of that. He went outside, went beyond those four corners to talk about a little more about the case than maybe he should have said. So as a consequence of that, our prosecutors spent a lot of time having to answer motions from the defense attorneys wanting all the evidence that supported those other things that this prosecutor said. So we had to spin our wheels and spend resources on something that we shouldn't have had to dealt with, but because it was said in public and got reported, we're having to deal with it. So what shouldn't we say if we're doing a news release or doing a news conference, okay? First, we never talk about the defendant's confession or his invocation of his Fifth Amendment rights not to testify, okay? Why not? The guy confessed. Well, we don't know that until we get to trial, whether or not that statement's going to be suppressed. And if we talked about his confession, and it's been widely reported all over the news media, and then we get to trial and it is suppressed for some reason, then one, we have egg on our face. The defense attorney raises a claim that we've poisoned the jury pool and asks that the case be moved to another jurisdiction to try it. So we wind up, instead of trying it in Birmingham, we're trying the case in Mobile or in Atlanta or in some cases Milwaukee, okay? So that increases everybody's cost tremendously when we have to pay for not only our witnesses, but also our prosecutors, our agents, our victim witness people, all to have to go to another location and try the case. So we don't want to talk about those things. We don't want to talk about what witnesses are going to testify about at trial. Why not? Because they may not testify. They may change their mind. They may testify differently. So we don't want to promise more than we can produce. We don't want to say that they say one thing and they get on the stand, they testify a little bit differently, and then they get cross-examined about, well, you know, these are the things that you reported to have said. So we just avoid that. Another thing is we don't want to talk about polygraphs. We don't want to talk about whether the defendant took one and failed it or took one and passed it. Polygraphs are generally inadmissible in court. And even if they were, we don't want to get into a battle of my polygraph examiner said that the defendant committed the crime, and then he hires a polygraph expert who comes into court and says, oh, but my polygraph expert says he didn't commit the crime. So we never want to get into a battle of the experts because we don't usually come out on the good end of that. We don't like to talk about the results of forensics examinations, whether it be some sort of a blood test, whether it be some sort of a DNA test. We just don't like to get into those results. Again, why not? Because they might be suppressed, or a portion of them might be suppressed. And again, we don't be caught, saying more than we can actually produce in a courtroom. We don't talk about a defendant's criminal history because that can be deemed prejudicial to him unless it's relevant to the charge. For example, if we charge a guy with being a felon in possession of a firearm, we can then talk about what that earlier felony was that he committed that made him eligible to be charged. We don't like to talk about potential defenses, okay? There's no good reason for us to do that. We don't want to put any doubt in anybody's mind about that. We don't want to talk about defenses or how we would overcome defenses. That's up to the defense to talk about that. We want to avoid that, stay away from it. We don't win in any way in that. And lastly, and probably one of the most important things is, we don't give our opinion about the guilt or innocence of a defendant. One, that's inadmissible at trial. If I got up in court and in my closing argument, I said, I believe that this defendant is committed this crime, that they're guilty, that's an automatic mistrial. So we don't want to be seen as doing that. Our position should be that we've uncovered these facts, we're going to go to trial, and we're going to let the jury decide what the true facts are and come back with a verdict. So we want to stay away from all those things. Now, we talked about what we shouldn't talk about. What can we talk about? We can talk about the facts that are set out in the indictment, like I said earlier. We can talk about the potential penalty that somebody's facing. Like if the defendant is convicted of this crime, he faces so many years in prison and such fine. No problem there. We can talk about who the investigative agency is and who the prosecutor is. If the defendant is a fugitive, we can ask for the public, and then it got published or broadcast. Well, you don't have that anymore. You have these guys that are out, they go out, they find out about that story, they write something up about it, and they post it. Nobody's reviewed it, nobody's checked it, it's out there. And when it gets on the internet, it's not just around here. If it gets on the internet, it can be nationwide or worldwide. And when it's on the internet, it is for forever. Okay, it's always out there. So news has evolved and changed. And that's something we have to keep in mind as we give these stories. They're not so much on that deadline to be there for the 5 o'clock or 6 o'clock news, but they need to get it out there right now. And they need to get it out there right now so they can beat this other reporter out here that's about to scoop and put it out. So it's an evolving industry, and it will continue to evolve. So I've talked a lot about this. Let me back up for just a minute and throw it open to you guys and see if you have any questions about this subject.
I'd like to know if you've had people that have been involved on releasing the information that have been involved in testifying in cases that you've had. You talked about how the media releases affect the case, or you had people that have been removed.
I have, and I try to avoid that every time that I can. Sometimes you can't. But if you have somebody who speaks to the media and then they testify, what they said to the media is fair game for cross-examination. So if they say one thing to the media and they testify about something else, the defense is going to wear them out with it. They're going to make them look silly. The best they can hope for is coming out with egg on their face. The worst that come out is the jury thinks they're lying because they said something differently. So I strongly encourage those folks that are going to be testifying not to make any statements to the media. We designate case agents that we don't let. We make sure that our case agents don't talk to the media, because I'm relying on them to work on the affidavits for search warrants and complaints and that sort of thing. So I know that they're going to be testimonial at some point. And so I don't want them having any more material out there that they can be cross-examined on. And that's something I talk to a lot of young police officers. And, and everybody has a Facebook account, a Twitter account, all kind of these accounts. And I caution them about being very careful about what they put on those accounts, because we've had many instances over the country where police officers were going to testify, but somebody found some stupid remark they made 2 years ago about something to one of their friends. It got posted, and then it's in the public, and then they get cross-examined about it, and it destroys their credibility. So I caution them to be very careful. I would suggest to them that they limit those social media sites that they are on, and then those that they are, be careful what they post and what other people post on their website. If somebody puts something, if you've got a Facebook site and somebody says something, really derogatory or anti-Semitic, some racist statement there, and you don't say, that's not right, or don't say that, that you're wrong. Even that can come back to haunt you. So you have to be very, very careful. And this is a new and evolving field, but we've had several witnesses over the country. We've had agents that have been giglioed. That is, that if they testify, this information is released about them such that it affects their ability to be a neutral witness for us. So we don't use them as in a testimony role anymore. When we do news conferences, I mentioned, we always like to have, if the U.S. Attorney's up there, we want to have the investigative agency or agencies. It can be, we a lot of times we'll have both the U.S. Attorney, the head of the FBI, the chief of police, it may be somebody from the state, have them all up there. Because I really believe that we are in a team effort. We're all on the same team. We work together, and we get up there and take credit together. It's not just the feds come in snatching something up. It's everybody. We couldn't make the case if we didn't all work together, so we're all mentioned. And for that reason, sometimes our news releases will talk about the case, and then we'll have a statement from the U.S. Attorney, a statement from the head of FBI, a statement from the police chief, a statement from the AG's office, whatever, which may be kind of silly in a way, but it gives them all a chance to be out there and to be quoted in the news media. So it's something I really believe in. I'll mention something else to you too. If you ever get involved in a big case, from time to time, we'll have really big cases here. We'll have national news. The Rudolph case was one. We had a church fires case a few years back where we had some folks burning down churches down in South Carolina. When you get those kind of cases, there's tremendous pressure from us to let Washington know what's going on, for the news media to find out what's going on, and the news media will go to great lengths to find out stuff. They will go to the courthouse and peruse every document they can find, because everything is on Pacer now, and they can go there and they can read everything that's been filed. They will also do things like they will shoulder surf. They will ride around. They will get on the elevators with your agents and try to be quiet in the corner and try to listen to your police officers and see what they say. They'll go where they eat lunch or eat breakfast, and try to sit at a table close to them and listen to what they talk about. So you have to remind them during the course of investigation, be mindful of who's around you, and if you talk about the case, outside of a law enforcement setting, be sure you know who else is there, because they will overhear what you say, and then bingo, they're going to release an anonymous source said. That's one of the problems. We have too are leaks in situations like that. I was talking to a guy that was AUSA in another district, and they had a big case. Well, it was a Boston bombing case, and they would have news conferences every hour to update the news media about what was going on. And he said that they would also have media. They would have besides those conferences, they would have a separate conference on the half hour for law enforcement, and they would talk about what the developments were. And that was so that the different agents could then let their higher-ups know what was going on. So we had one guy that would be at this half-hour news conference, and he contacts his headquarters in Washington and tells them what's going on. You got somebody from the state there, and he contacts his headquarters and lets them know what's going on. And many times, by the time they made it to the news conference at the top of the hour for the news media, they already knew it. They already knew what was talked about at that earlier news conference. So, and that was a huge case, you know, but all the news media were under tremendous pressure. Like we were under pressure to catch the people. They're under pressure to report that. And they will go to great lengths to try to find out about your case. Yes, sir.
Just wondering, you know, one thing we talked about is building that relationship with media, working with them, get our story out, and all those things. But I'm just wondering, have you ever had a scenario where you had to either kind of put pressure on a media person that if you run that, you know, there's going to be some consequences or something like that, or maybe they ran something that they were not supposed to, and you had to kind of call them on it, or have you ever had a situation where you kind of had to call them to the carpet a little bit that you could talk about?
No. Help in locating that person. If there are other victims of the defendant's conduct, we can make an appeal for those victims to come forward and contact authorities. We can also have the lead prosecutor, which is usually the U.S. attorney for us, or the head of the investigative agency, can make a general statement about the investigation or about the charge. And that would be something like, we would say, so-and-so state agency working with so-and-so federal agency conducted a lengthy investigation which resulted in this charge today. That's an example. Okay, another one would be, this is a particularly heinous crime because it affects our most vulnerable victims, children or the elderly. So they can say something general like that, but they can't be much more specific. So, we've talked about what we can say and what we can't say and some of the reasons behind that. Let's talk about a couple of worst case scenarios, okay? Do you guys remember the Duke lacrosse case that happened a few years back? Remember that? Okay, all right. That's probably one of the most egregious pretrial publicity cases that have happened in the last quarter century. For those who don't remember, we'll talk about it for a second. You had 3 members of the Duke lacrosse team that were charged with rape. That they were charged. The rape was supposed to have happened about March the 13th of 2006. At the time, the DA of Durham County, where Duke is located, was a guy named Mike Nifong. Mr. Nifong was briefed on the case on March 27th, just under 2 weeks after the alleged crime occurred. Nifong immediately began making statements to the news media. By his own accounts, he gave 50 to 70 interviews about this case. He suggested that the alleged rape was a hate crime. Some of the statements he made to the news media were comments on the alleged failure or the refusal of some of the team members to cooperate with law enforcement. He gave his opinion that the crime had been committed by the young men that were under investigation. He said that the crime was racially motivated. He said that one or more of the young men were guilty of this crime. Now, the fallout for these people was almost immediate, okay? Within a week, the lacrosse soccer coach was forced to resign. Duke canceled the remainder of its lacrosse season. The 3 men were kicked out of college. Duke University was vilified by people on campus, off campus, in the news media for fostering an atmosphere that would allow this type of a crime to occur. We even had some civil rights leaders show up and make speeches with the victims about what a horrible crime it was and how terrible Duke was. Well, the big problem for Mr. Nifong was that the facts didn't support his theory of the case. I told you this was back in March and April. By April the 10th, a North Carolina laboratory did a DNA examination, and it failed to connect any of the young men to the crime. Mr. Nifong found out about that. He hired another lab to do another DNA test on May the 12th. And that lab did the test, and those results were no more helpful than the ones from North Carolina. Undeterred, Mike Nifong went ahead and presented the case to the grand jury, and on May 16th of 2006, all three men were indicted. And he held a huge news conference to announce the indictment, read it, it was on CNN and Fox and everybody, and it was national news. As the case rocked along and discovery was turned over to the defense counsel, the judge became very concerned about the case, and it was sort of a media circus. And the Attorney General for North Carolina stepped in and took over the case and conducted an independent investigation of the evidence. By April 2007, about a year later, the Attorney General for North Carolina dropped all charges against the young men and said that they were innocent. He said that the victims were, let me quote this, he said the young men were victims of a tragic rush to accuse. And he called Mike Nifong a rogue prosecutor. The North Carolina Bar Association also looked into this. Ethics charges were filed against Nifong. They included making public statements that were prejudicial to the administration of justice and heightened public condemnation of the accused. And they listed more than 100 examples of statements that Nifong made to news media in their complaint. In June 2007, Mike Nifong was disbarred from practicing law. On the disbarment, they said that he had committed dishonesty, fraud, deceit, and misrepresentation. So he lost his ticket to practice law because of all the things he said to the news media in that case, and for going forward in the case that he had good reason to know probably that the facts didn't support his theory. But he got swept up in the media circus of the time, and he liked seeing himself on TV, I guess, because he went way out of bounds with this case, much further than he should ever have gone. That's an example of a worst case example of what can happen. Let's talk about another case that maybe is a little bit older, but I bet you guys remember the name, Richard Jewell. Anybody remember Richard Jewell? Okay. Richard Jewell was a security guard that was working at the Olympics in Atlanta, at the Centennial Olympic Park, okay? The night that a bomb, that was the largest pipe bomb that had ever been placed at that time in the United States, was placed next to a TV tower there. And Centennial Olympic Park was sort of like downtown, or downtown for the Olympics. I mean, it's where everybody went at night. You had all the athletes and all the tourists, and everybody went there. They had music going on, and it was just a big party every night at this place. And it held like 50 to 70,000 people there. So they got a phone call a little after midnight that there was a bomb in Centennial Olympic Park, and they started looking for it. And Richard Jewell found a backpack that was underneath a little bench there, and he opened it just enough to see the pipe bomb that was in there. So he started moving everybody back, helping to move people away out of the area, and they did a pretty good job of doing that unfortunately, when the bomb exploded, there was one lady that was killed, Alice Hawthorne. She was struck by a nail, hit her in the head. She was about as far as this room is long away from the device when it exploded. Richard Jewell was hailed as a hero the next day. He had saved who knows how many lives by what he had done. He had found the bomb, and he was front page news as one of the heroes of that incident. Well, in 3 days, the Atlanta Journal-Constitution ran a story where they said that Richard Jewell was a possible suspect in the Atlanta bombing. And that the FBI made that assessment based on a lone bomber criminal profile. I don't know if you guys know, but the behavioral science unit in the FBI are their criminal profilers, and they prepare profiles of different types of individuals who commit crimes. And this was one they had done several years earlier, and they pulled it back out and thought that he met the criteria. Well, the news media went on to call him also a person of interest. He was hounded by the news media. They followed him everywhere he went. They went to his apartment and set up camp, literally surrounding his apartment. He couldn't go anywhere without being followed by the news media. He was again condemned and vilified by people in the community. Everyone thought he was guilty. It was all over the newspapers and TV at the time. He lost his job because of it, and it proved very difficult to find another job because everybody thought he was involved in the bombing. He had to move out of his apartment because of all the news media that were there surrounding it. The other tenants had trouble getting in and out of his apartment. Even 2 of the victims of the bombing actually sued him over this. And as we all know, ultimately, he had absolutely nothing to do with it. Eric Robert Rudolph was the one who had actually set the bomb. So Richard Jewell suffered all these consequences, and even though he was exonerated for years, he was still looked upon with something that he was connected to the bombing in Atlanta. People wouldn't remember the details, but they remembered that name. They remembered Richard Jewell. So that was a stigma that followed him for the rest of his life. Now, the Atlanta Journal-Constitution and the TV station in Atlanta had I believe, a very large undisclosed settlement with him over that, where he sued them for making false statements about him in the media. But Richard Jewell ultimately died at the age of about 44, and a lot of people felt that the stress that he'd been placed under in this situation was one of the things that really contributed to his death. And that's very likely, very possible. You know, we live in an age, I'm telling on myself now how old I am. I can remember when I started practicing law, you had the newspapers and you had a couple, 3 TV stations here in town, and that was the news. That's how you got your news. We've evolved to having 24-hour news stations that have, instead of the news cycle being, about 24 hours or maybe 12 hours, now it's shrunk down to used to be just hours. And we've evolved beyond that now to having, web-based news services. And most young people get their news off the internet. So we have news cycles that last literally minutes now. So things move a lot faster. And news organizations, news reporters, those that are still out there, they are under tremendous pressure to get information quickly and to post it. So used to, you had editors who the reporter would go out, find the news, find the story, they would write something up, send it to the editor would review it,